Thank you for joining us for our video about the fiduciary duties of board members of nonprofit organizations. My name is Jody Adler, and I'm the director of the Community Law Project and Pro Bono Relations at the Chicago Lawyers Committee for Civil Rights. The Community Law Project provides free legal assistance to Chicago-based economic development and social service organizations and eligible entrepreneurs for their business legal needs. The following video is part of a series we've developed for persons serving on nonprofit boards to help them understand the role of the directors on those boards. The videos cover board responsibilities, fiduciary duties, directors and officers' responsibilities, conflicts of interest, the relationship between the board and the executive director, and recruitment of directors and their orientation. If you have questions about the content of this video or any of the other videos or need pro bono legal assistance, please email us at clp@clccrul.org or visit our website listed at the conclusion of each section. This video is on fiduciary duties. So what are fiduciary duties? Fiduciary duties are legal obligations imposed on people who are trusted to act on behalf of third parties. It requires that everybody on a board act on behalf of the board and the organization in the best interests of that organization. In the case of a nonprofit, directors and officers must act in good faith and honesty, not just on behalf of the board or the organization, but also on behalf of donors and the general population. Fiduciary duties apply to trustees and directors whether they're serving on nonprofit boards or on for-profit boards. There is a difference between the fiduciary duties for those serving on for-profit boards and nonprofit boards. On a for-profit board, the fiduciary duties are the duty of care and the duty of loyalty. On a not-for-profit board, those same duties apply, but there's also the duty of obedience. In this video, we'll explore each one of these fiduciary duties in more detail. And we'll start with the duty of care. The duty of care really affects how the board makes its decisions. It means that the people who are sitting on the board have to have the appropriate care when they're making determinations on what that board will do on behalf of the organization. What does appropriate care mean? Appropriate care means that the directors act in good faith with the same level of care an informed person would act in a similar position when being approached by that issue. Basically what it says is that if you are serving on a board of directors and making a decision, the duty of care requires that you act as a reasonable person would act when confronted in a similar situation. It doesn't require that you be an expert. It simply requires that you use reasonable care to make your decisions. Practically speaking, what does that mean? Practically speaking, what that means is that before a board meeting, you should be getting an agenda for that meeting. Before a board meeting, you should be getting a packet of information that includes details of the things that you're going to be discussing. As a director on that board, to meet your fiduciary duty of care, you have to read those things, and you have to read them critically, because you have to be informed before you make your business decisions. So what that means is that if you read something and you have questions about it, when you go to the board meeting, you ask those questions. You have to critically analyze the information that you receive. And you have to consider what reasonable alternatives exist before you make those decisions. You want to make sure that you're engaged in the decision-making process. Again, you don't have to be an expert, because what the duty of care also says is that directors can rely on experts. But you have to know enough about what the decision is or what the discussion is going to be to know when to ask for expert opinions. Staff may be considered the experts in certain areas, but in some situations you may need to hire somebody or consult with somebody who's got a more professional degree to address those issues. It may be an attorney, it may be an accountant or a CPA or somebody else. But part of the duty of care simply requires that you know enough to know when you need to ask for additional information, either from the staff or from a professional. The duty of obedience is the fiduciary duty that applies only to not-for-profit directors and officers. It doesn't apply to for-profit boards at all. It requires that you be familiar with the laws that apply to the organization on which you serve on the board. It requires that you understand what the governing documents of that organization looks like, whether it's the articles of incorporation, the bylaws, whether there are employment policies, What the duty of obedience requires the director to do is review those documents and understand what they mean. And if you don't understand what they mean, the duty of care says you need to ask questions about that to make sure that you do understand what they mean. It also requires that you know what the mission and the vision of the organization are. You want to make sure that the actions of the organization, so the decisions the board is making to further the goals of that organization, really fit within what the mission and the goals and the vision of that organization are. So as a director, if you are joining a board, and we'll talk about this in our recruitment and orientation slide, you want to make sure that you've seen the bylaws and have reviewed the bylaws on a fairly regular basis, and that you've seen the articles of incorporation for the organization. And again, if there's an employment handbook, that you've seen the employment handbook, so you're familiar with the requirements are there. You also want to make sure you understand what the general laws are that apply to the not-for-profit on which you serve. Again, the practical application of the duty of obedience requires that the organization and the board manage that the organization is moving further towards meeting its goals and its mission and purposes in compliance with local, state, and federal laws. It means that as a director on the board, you're making sure that you're not making decisions for the organization to change its mission without actually assessing what the mission is and whether that makes sense, and that you're not chasing dollars. There's something that happens in some nonprofit organizations when their goal perhaps is to provide homeless shelter for organizations, but then they learn about funding in a different area and decide that they're going to go try to get that funding. As a director on the board, your responsibility is to make sure that if there's going to be a pivot of the mission of the organization, that's analyzed, and it's not something that's simply done because there's other funding that's available. The duty of obedience, again, simply requires that you be familiar with the laws that impact the organization, its mission, its vision, and its governing documents. The duty of loyalty is the third duty that applies to directors who serve on nonprofit boards. And this applies to the substance of the board deliberation as opposed to the duty of care. It looks at the motives of the directors in making decisions, the purposes of the directors, and the goals behind those decisions. Most violations of fiduciary duties arise in the area of the duty of loyalty. So let's look more closely at what this means. The duty of loyalty requires that a director always act in the best interest of the organization and not for his or her own benefit. It means that whenever a decision is being made or a course of action is being followed, the director's own interest or that of his or her family or a business in which he or she or a family member has a significant interest is always subordinate to the interest of the organization. Violations occur when an individual who serves on the board or has a substantial amount of control over the organization doesn't disclose his or her personal interest and makes a decision that may personally benefit them. So what a conflict really is, what happens here is that somebody may have dual loyalties. They may have an interest for their own personal business, and they may have the interest of the organization. And frequently, both of those interests come into play, and it becomes very difficult to make a decision. But the duty of loyalty always puts forth the interest of the organization before your own. So let's look at a practical application of this. There's two different things that people talk about. One is usurping a corporate opportunity, and the other one is using your own authority for your own benefit. Usurping a corporate opportunity really applies when the organization is going to enter into a financial transaction, whether it's a contract, whether it's compensation, and it gets bids from, let's say, 3 vendors to make a decision about who to contract with. And one of the bidders is a corporation that has a substantial ownership by one of the directors. The organization enters into a contract with that organization, and the director doesn't disclose that they have an interest. The director may have been engaged in the conversation about entering into that contract, may have talked about what a great deal it was for the organization, and then they have violated their duty of loyalty to the organization because they've put their own personal interest ahead of the interest of the organization. Using your own authority is if you're sitting at a board meeting and you learn about something that the organization is considering that may also benefit yourself or your business or a family member, and you jump out of that meeting and you take advantage of that opportunity for yourself. Those both would be violations of the fiduciary duty of loyalty. So what are the takeaways regarding the fiduciary duties? The fiduciary duties, again, for nonprofit directors are the duty of care, the duty of obedience, and the duty of loyalty. There's a lot of nuance to all of these, but the most important thing to remember is that to meet the fiduciary duties, you just have to make sure that you read material that you obtain before the meeting, you go to the meetings, you ask questions at the meeting, you critically analyze the information that you have learned about, you know when to hire a professional, you always put the interests of the organization above your own, a family member's, or a business, and that you always are making sure that the decisions being made are in the best interest of the organization, and that you are always taking into account the mission, the governance documents, and the purposes of the organization to make sure that decisions are being made that follow that mission, follow that vision, and are in compliance with the laws and the governing documents of the organization. If you have questions about the fiduciary duties or need pro bono legal assistance concerning any of these issues, please feel free to email us at clp@clccrul.org or visit our website, which will be on the slides. Thank you.